Good afternoon, my name is Nikita. In today's video, I'll be discussing the interpretation of the term shared household as defined under Section 2S of the Protection of Women from the Domestic Violence Act 2005 with the help of the judgments of the Hon'ble Supreme Court and Hon'ble High Courts. The Protection of Women from the Domestic Violence Act 2005, hereinafter referred to as the Domestic Violence Act, came into force on 26th of October 2006. Before coming into the force of this act, the remedies available to a victim of domestic violence were limited in nature. The woman either had to go to a civil court for a decree of divorce, or she could initiate criminal prosecution for the offence punishable under Section 498A of the IPC, that is, for the offence of cruelty. Thus, in both the proceedings, no emergency reliefs were available to a victim of domestic violence. Thus, the enactment of the Protection of Women from the Domestic Violence Act 2005 is a milestone for the purpose of protection of women in this country. It is a further step to secure social justice by way of a legislation. Before understanding the concept of shared household, let us first understand the definitions of aggrieved person, domestic relationship, and respondent as defined under the Domestic Violence Act of 2005. The term aggrieved person has been defined under Section 2A. The term domestic relationship has been defined under Section 2F. The term respondent has been defined under Section 2Q, and the term shared household has been defined under Section 2S. Now let us first see the definition of aggrieved person, which has been defined under Section 2A. So, the definition of aggrieved person reads as follows. Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to an act of domestic violence by the respondent. Now let us see the definition of domestic relationship, which has been defined under Section 2F. Domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household, whether they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. The term respondent has been defined under Section 2Q and it reads as follows. Respondent means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this act. The proviso reads as follows. Provided that the aggrieved wife or a female living in the relationship in the nature of marriage may also file a complaint against a relative of husband or the male partner. Now let us see two important pronouncements relating to the definition of respondent 2Q. So the very first pronouncement is the case of Sandhya Manoj Wankhede versus Manoj Bhimrao Wankhede. Now this judgment was delivered by the Hon'ble Supreme Court in the year 2011. And in this case, the main issue was that whether a complaint can be filed under the Domestic Violence Act only against the adult male person and not against the female relatives of the husband, that is to say the mother-in-law and the sister-in-law. So The Honorable Supreme Court has held in this case that the proviso, it widens the scope of the definition. The Honorable Supreme Court held that the Section 2Q does not exclude the female relatives of the husband or the male partner from the scope of complaint that can be filed under the Domestic Violence Act. The court held that the legislature never intended to exclude the female relatives of the husband or the male partner from the scope of complaint that can be filed under the Domestic Violence Act of 2005. So this was the first pronouncement. Let us now see the case of Hira Lal P. Harsora and others versus Kusum Narottam Das, Harsora and others. This judgment was delivered by the Honorable Supreme Court in the year 2016, and in this case, the constitutional validity of Section 2Q came into question. The Honorable Supreme Court held that the words adult male which appear in Section 2Q will stand deleted since these words do not square within Article 14 of the Constitution of India, which is the right to equality. Consequently, the proviso to Section 2Q also stands deleted as it is now rendered odious. Now let us see the definition of shared household, which has been defined under Section 2S and Section 17, which deals with the right of residence of a woman in a shared household. The term shared household has been defined under Section 2S and which reads as follows. Shared household means a household where the aggrieved person lives or at any stage has lived in a domestic relationship either singly or along with the respondent, and includes such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title or interest or equity, and includes such a household which may belong to a joint family of which the respondent is a member, irrespective of the fact that whether the respondent or the aggrieved person has any right, title or interest in the shared household. So this was the definition of shared household, which has been defined under Section 2S. Now let us see the right of residence of a woman in a shared household, which has been dealt under Section 17 of the Protection of Women from the Domestic Violence Act 2005. So, Section 17 starts with a non-obstante clause. It states that notwithstanding anything contained in any other law for the time being in force, every woman in a domestic relationship shall have the right to reside in a shared household, whether or not she has any right, title or beneficial interest in the same. Subsection 2 provides that the aggrieved person shall not be evicted or excluded from the shared household or any part of it by the respondent, save in accordance with the procedure established by law, and this is in consonance with Article 21 of the Constitution of India. Now I'll be discussing the case of SR Batra versus Taruna Batra. Now this judgment was delivered by the Honorable Supreme Court in the year 2006 and it is a two-judge bench decision. In this case, the respondent Taruna Batra was married to Amit Batra, who is the son of appellants. After the marriage, they both started to live in the house which was owned by the applicant number 2, who is the mother-in-law of the respondent, on the second floor. The respondent's husband had filed for a divorce petition, and it was alleged that as a counterblast to the above mentioned divorce petition, the respondent had filed an FIR under section 498A, section 406, 506 and 34 of the IPC against her husband and against her in-laws, that is the mother-in-law and the father-in-law being the appellants. The respondent then later shifted to her parents' residence because of a dispute with the husband, and later on, when she tried to enter the house of the appellant number 2, she found that the main entrance gate was locked. The respondent had filed a suit for mandatory injunction so as to enable her to enter the house. The appellants, on the other hand, stated that their son had shifted to Ghaziabad in his own flat even before the litigation had started. The learned trial court had granted the temporary injunction restraining the appellants from interfering with the possession of the respondent. However, the learned senior civil judge in appeal held that neither the respondent nor her husband, they were residing in the premises in question, and the respondent had no right to the properties other than that of the husband. Hence, the temporary injunction application was dismissed. The matter reached before the Honorable Delhi High Court, and the Honorable Delhi High Court held that the property in question was the matrimonial home of the respondent, even if her husband had shifted to his own house. A mere change of residence would not shift the matrimonial home, particularly when he has filed a divorce petition. Now let us see the proceedings before the Honorable Supreme Court. The Honorable Supreme Court observed that the house in question, it belonged to the mother-in-law of the respondent and it did not belong to her husband, Hon'ble Batra. Secondly, the court rejected the contention that the definition of shared household includes a household where the aggrieved person lives or at any stage has lived in a domestic relationship. Thirdly, the court further held that if this aforesaid submission was to be accepted, then it would mean that wherever the husband and wife have lived together in the past, that property becomes a shared household. It was quite possible that the husband and wife may have lived together at dozens of places, for example, at husband's father's place, uncle's place, aunt's place, or at nephew's place. And if this interpretation is to be accepted, then all the houses of the relative's husband will become shared household, and the wife can insist in living in all these households merely on the ground that she had stayed in these houses with her husband in the past. Such a view would be absurd and would lead to a chaos in the society. So, the Honorable Supreme Court held in this case that firstly, the wife is entitled to claim a right of residence in a shared household, and a shared household would mean a house belonging to or taken on rent by the husband, or a house which belongs to a joint family of which the husband is a member. The Honorable Supreme Court further observed that the claim for alternative accommodation can only be made against the husband and it cannot be made against the relatives of the husband. Now let us see the observations of Honorable High Courts with regard to the definition of shared household. So the very first case which I am going to discuss is the case of Vandana versus T. Shrikant. Now this judgment was delivered in the year 2007 and it was delivered by the Honorable High Court of Madras. And in this case, the Honorable High Court of Madras has held that a narrow interpretation to Section 2F, 2S and Section 17 would leave many women in distress and without a remedy. Therefore, a healthy and a correct interpretation to Section 2F, 2S and Section 17 would be that the words live or at any point of time lived would include in its purview the right to live. Now let us see the case of Ivneet Singh versus Prashant Chaudhary, and this judgment was delivered in the year 2010 and it was delivered by the Honorable High Court of Delhi. In this case, the Honorable High Court of Delhi has held that the definition of shared household, it emphasizes on the very factum of domestic relationship and no investigation into the ownership of said household is necessary as per the definition. Now let us discuss the case of Satish Chandra Ahuja versus Neha Ahuja, a judgment which was delivered by the Honorable Supreme Court in the year 2020 and it is a 3-judge bench decision. The brief facts of the case are as follows. Raveen Ahuja, who is the son of appellant, was married to respondent Sneha Ahuja in the year 1995 and after the marriage, the couple started to live in the house which was purchased by the appellant in the year 1983. There was a marital discord between the husband and wife and the husband had filed for a divorce petition under Section 13, subsection 1, clause 1A and clause 3 of the Hindu Marriage Act 1955. The respondent had filed an application under Section 12 of the Domestic Violence Act alleging that she had suffered mental and emotional trauma and this application was filed against her husband and against her in-laws. The learned Chief Metropolitan Magistrate had passed an interim order to the effect that the appellants shall not alienate the shared household nor they would dispossess the respondent or her children until the orders of the competent court in this behalf. Aggrieved by the interim order which was passed by the learned Chief Metropolitan Magistrate in the Domestic Violence Act proceeding, the appellant had filed a suit for permanent injunction impleading Sneha Ahuja, the respondent in this case, as the sole defendant. The appellant had stated that he and his wife, they were themselves the victim of domestic violence and they wanted to live peacefully in their self-acquired residence. A written statement was filed by the defendant pleading that the house property or the premises in question was acquired by the appellant through the joint family funds and it was not his self-acquired property. The learned trial court proceeded to decide the application which was filed under Order 12, Rule 6 of the Code of Civil Procedure 1908 which was filed by the appellant and decreed the relief of permanent injunction. The matter reached before the Honorable Delhi High Court. The Honorable Delhi High Court firstly set aside the decree of trial court and remanded the matter back to the trial court for fresh adjudication. The Honorable Delhi High Court held that the trial court had passed the decree merely on the ground that whether the property in question was a self-acquired property and gave no regard to the fact that a domestic violence case was still pending adjudication before the court. The matter reached before the Honorable Supreme Court and I'll be first discussing two issues which are relevant to our present discussion. So, the two main issues before the Honorable Supreme Court were as follows. So the very first issue is that whether the definition of shared household as defined under Section 2S of the Domestic Violence Act 2005 has to be read to mean that the shared household can be a household of a joint family or in which the husband of the aggrieved person has a share. So this is the very first issue. Now let us see the second issue. The second issue is whether the judgment of the Hon'ble Supreme Court in the case of SR Batra versus Taruna Batra, which was delivered in the year 2006, has not correctly interpreted the provision of Section 2S of the Domestic Violence Act of 2005 and does not lay down a correct law. Now let us see how the Hon'ble Supreme Court has answered these issues. Firstly, the Hon'ble Supreme Court has held that the definition of the term shared household is exhaustive in nature. The Hon'ble Supreme Court has held that the definition of the term shared household, it uses both the terms, means and includes, and thus it is an exhaustive definition. Now let us see the explanation of the term shared household as given by the Hon'ble Supreme Court. The Hon'ble Supreme Court has held that the definition of shared household, it can be divided into two parts. Firstly, which follows the word means, and second, which follows the words includes. And the court has held that from the definition, it is quite clear that it is not the requirement of the law that the aggrieved person may either own the premises jointly or singly, or tenant it jointly or singly. Secondly, the household may belong to a joint family of which the respondent is a member, irrespective of the fact that whether the aggrieved person or the respondent has any right, title, or interest in the same. Thirdly, the shared household may either be owned or tenanted by the respondent jointly or singly. Now let us see the meaning of the expression at any stage has lived. The expression at any stage has lived has been used to protect the women from denying the right to live in a shared household merely on the ground that on the date when the application is filed, she was excluded from the possession of the house or was temporarily absent. The use of the expression at any stage has lived has been used for the above mentioned purpose, and it is not with the object that wherever the aggrieved person has lived with the relatives of husband, all such houses shall become a shared household, which was never the legislative intent. The Hon'ble Supreme Court also held that the apprehension that has been expressed in the case of SR Batra versus Taruna Batra was not the true apprehension. Now let us see the interpretation of the term lives or at any stage has lived as given by the Hon'ble Supreme Court. The Hon'ble Supreme Court has held that the words lives or at any stage has lived, they are to be given the normal and the purposeful meaning. Secondly, the living of a woman in a shared household has to refer to a living which has some permanency. Thirdly, mere fleeting or casual living at different places shall not make a shared household. Now let us see the right of residence which has been dealt under Section 19 of the Domestic Violence Act. So, the Hon'ble Supreme Court has held that the right of residence under Section 19 is not an indefeasible right of residence in a shared household, especially when the daughter-in-law is pitted against the aged father-in-law and the mother-in-law. While granting reliefs in both the proceedings, that is, in an application under Section 12 of the Domestic Violence Act or in a civil proceeding, the court has to balance the right of both the parties. Now let us see how the Hon'ble Supreme Court has answered the issues. Firstly, the Hon'ble Supreme Court has held that with respect to first issue, that the shared household cannot be read to mean that the shared household can only be a household of a joint family of which the husband is a member or in which the husband of the aggrieved person has a share. So this is the first issue. Now let us see the second issue. With respect to second issue, the Honorable Supreme Court has held that the judgment of the Honorable Apex Court in the case of SR Batra versus Taruna Batra had not correctly interpreted Section 2S of the Protection of Women from the Domestic Violence Act 2005, and it does not lay down a correct law. So, by far, I have discussed the cases of SR Batra versus Taruna Batra. This judgment was delivered in the year 2006, and also I have discussed the case of Satish Chandra Ahuja versus Neha Ahuja, a judgment delivered by the Honorable Supreme Court in the year 2020. Now let us discuss the analysis of both these cases. See, the earlier proposition of law as laid down in the case of SR Batra versus Taruna Batra, a judgment delivered by the Honorable Supreme Court in the year 2006 was that the wife was entitled to claim a right of residence in a shared household. And the shared household would mean a house belonging to or taken on rent by the husband, or a house which belongs to a joint family of which the husband is a member. After the pronouncement of judgment by the Honorable Apex Court in the case of Satish Chandra Ahuja versus Neha Ahuja, a judgment delivered in the year 2020, now the wife has a right of residence in her matrimonial home irrespective of the fact that whether her husband has any right of ownership or share in it. The act has to be interpreted in a manner which effectuates the very purpose and the object of the act. Section 2S, read with Section 17, read with Section 19 of the Domestic Violence Act, it grants entitlement in favor of a woman the right of residence in a shared household, irrespective of her having any legal interest in the same. Now let us discuss the case of Prabha Tyagi versus Kamlesh Devi. Now this judgment was delivered by the Honorable Supreme Court in the year 2022. The brief facts of the case are as follows. An application under Section 12 of the Domestic Violence Act was filed by the petitioner, being the aggrieved person in this case, and also the widow, and it was filed against the respondent mother-in-law seeking residence orders and the return of a Sridan. The learned special judicial magistrate had partly allowed this application, which was filed by the aggrieved person. Now this order, which was passed by the learned special judicial magistrate, it got reversed by the appellate court, and the learned additional sessions judge Dehradun had set aside the order primarily on the ground that after the death of the husband, there was no subsisting domestic relationship between the respondent and the complainant. The appellate's court order was affirmed by the Honorable High Court of Uttarakhand, and the matter reached before the Honorable Supreme Court. With respect to the first issue, the Honorable Supreme Court has held that it was not mandatory for the aggrieved person when she is related by consanguinity, marriage, or through a relationship in the nature of marriage or adoption, or are family members living together as a joint family to actually reside with those persons against whom the allegations have been leveled at the time of commission of domestic violence. The Honorable Supreme Court has held that the right to reside in a shared household would include not only the actual residence, but it also includes the constructive residence in a shared household. Now let us see how the Honorable Supreme Court has answered the second issue. The Honorable Supreme Court has held that there should be a subsisting domestic relationship between the aggrieved person and the person against whom the relief is claimed vis-a-vis the allegation of domestic violence. However, it is not necessary that at the time of filing of an application by the aggrieved person, such domestic relationship should be subsisting. So, The Honorable Supreme Court has held that it is not necessary that at the time of filing of an application by the aggrieved person, the domestic relationship should be subsisting. So, we have seen that the interpretation of the term shared household has changed with the passage of time. Now let us discuss the case of Ritu Chanelia versus Amar Chanelia and others, and this judgment was delivered by the Honorable Delhi High Court in the year 2023. In this case, the respondent number 1 and the respondent number 2, they are the petitioners-in-laws and they are both senior citizens. The respondent number 3 is the husband of the petitioner. The parents have preferred an eviction petition against the petitioner before the district magistrate of the government of NCT of Delhi, and it has been filed under the Maintenance and Welfare of the Parents and Senior Citizens Act 2007. The district magistrate had directed the eviction of petitioner from the property. The petitioner had preferred an appeal, and the said appeal was allowed and the order of eviction was set aside, but however the respondents were permitted to stay in the property. The matter reached before the Honorable Delhi High Court, and the Honorable Delhi High Court had placed reliance on the decision of the Honorable Supreme Court, which is the case of Satish Chandra Ahuja versus Neha Ahuja, and this judgment was delivered in the year 2020. So, the Honorable Delhi High Court has held in this case that the concept of shared household provides that the right of a daughter-in-law in a shared household is not an indefeasible right and it cannot be to the exclusion of in-laws. The daughter-in-law, while claiming her right of residence in a matrimonial home or in a shared household, cannot be seen to argue that the in-laws ought not to live with her in the shared household. If the circumstances exist which demonstrate that they cannot live together, then in that case, alternate accommodation may also have to be explored for the daughter-in-law. The Honorable High Court noted in this case that the petitioner was currently in occupation of the entire property, which consisted of one floor, and was not willing to consider to shift to any alternate premises, though the same was offered by the in-laws. The Honorable High Court issued the following directions in this case, which are as follows. Firstly, the petitioner and her son, they shall occupy one room in the suit property, and the respondent number 1 and the respondent number 2 together, they shall occupy one bedroom. Secondly, the grandson, being the petitioner number 2, shall be permitted to use the room number 3, that is the third bedroom, for his studies and tuition purposes. However, the said room will be accessible to all the parties, that is to all the occupants. Thirdly, the common area, which is the kitchen and the drawing room, shall also be used by all the occupants. Fourthly, the in-laws are permitted to put the CCTV cameras and the recordings of the same shall be accessible to the petitioner. Now let us see the conclusion. The Honorable Supreme Court in the case of SR Batra versus SR Batra, a judgment delivered by the Honorable Supreme Court in the year 2006, has held that the wife has a right of residence in a shared household, and a shared household would mean a house belonging to or taken on rent by the husband, or a house which belongs to a joint family of which the husband is a member. After 13 years, the judgment in the case of SR Batra versus SR Batra was overruled in the case of Satish Chandra Ahuja versus Neha Ahuja, a judgment delivered by the Honorable Supreme Court in the year 2020, and in this case, the court has given a wider interpretation to the term shared household. The Honorable Supreme Court in the case of Satish Chandra Ahuja versus Neha Ahuja, by giving a wider interpretation to the term shared household, has held that the definition of shared household cannot be read to mean that the shared household can only be a household of a joint family of which the husband is a member, or in which the husband of the aggrieved person has a share. The Honorable Supreme Court, in the case of Prabha Tyagi versus Kamlesh Devi, a judgment delivered by the Honorable Supreme Court in the year 2022, in this case, the court further expanded the interpretation of right of residence in a shared household by invoking the concept of constructive residence and non-requirement of a subsisting domestic relationship. The judgments in the cases of Satish Chandra Ahuja versus Neha Ahuja and in the case of Prabha Tyagi versus Kamlesh Devi are progressive judgments, as they have strengthened the right of residence of a married woman in a shared household where she stays. I hope you all have understood the interpretation of the term shared household as discussed in this video with the help of the judgments of the Honorable Supreme Court and Honorable High Courts. Thank you.